हेलो एवरीवन, वेलकम बैक टू द विजडम वेंसडे सीरीज। आज हम जिस टॉपिक के बारे में बात करने जा रहे हैं, इट इज कॉल्ड द एडीआर mechanisms. Whenever there is a dispute between two people, we assume that that dispute would go to a court. But there are certain drawbacks of all disputes going to courts. Firstly, it is very time consuming. It takes years or even decades for a dispute to come to a conclusion in court. Secondly, it drains a lot of financial resources of the parties. And thirdly, courts in the Indian legal system are already very overburdened, and this only increases their burden even more. So इन सारी problems का एक collective solution निकल के आता है, which is called the ADR mechanisms. Now, what are these ADR mechanisms? ADR stands for Alternative Dispute Resolution. It is a process by which disputes are resolved amicably between the parties without judicial intervention. So, what happens in ADR is that a third person or the parties themselves try to resolve those disputes without the intervention of a court or a judge. और ये काफ़ी एक कॉन्फिडेंशियल प्रोसेस होता है और पार्टीज को काफ़ी ऑटोनॉमी होती है टू डिसाइड हाउ दे वांट टू गो फॉरवर्ड विद द प्रोसेस एंड हाउ दे वांट द आउटकम टू बी लाइक. So ADR is not something very new to this world, right? ADR has existed since time immemorial. If we think about it, in ancient India, in ancient Greece, China, there have been instances and there have been recorded instances where people have used mechanisms such as arbitration and mediation to resolve their disputes. Even we see in our daily lives कि कहीं कोई झगड़ा हो जाता है तो घर के बड़े try to resolve those. So that is basically what ADR is, where you do not go to court and some neutral third party helps you resolve those disputes and come to an amicable solution, which is win-win for both the parties. Now let us see the four major ADR mechanisms that exist. Firstly is arbitration. Arbitration is a procedure in which a dispute is submitted by agreement of the parties to one or more arbitrators who make a binding decision on the dispute. So these arbitrators, they make a binding decision which is called an award. So this is more of like a formal procedure. It is not as informal as the other mechanisms that we will discuss. There is still a procedure that you have to follow and evidences that you have to submit. And the decision that comes out of arbitration is also binding and it is called an award. So what happens in arbitration is that there is this neutral third party, or there will be like three arbitrators, and they will listen to your problems, to your dispute, and then they will give an award, which is a binding decision for that dispute. And parties agree to arbitration, and arbitration cannot exist without the consent of both the parties to agree to submit their dispute to an arbitration. Then the second mechanism is mediation. So, what is mediation? In a mediation procedure, a neutral intermediary, the mediator, helps the parties reach a mutually satisfactory settlement of their dispute. So, here in this process, there will be this one mediator who's a neutral third party who will only make sure that the two parties who are in dispute, they have a communication and slowly they reach an amicable settlement. They reach a cooperative settlement which is win-win for both the parties. As compared to arbitration, this is more of an informal procedure, and whatever result comes out of it is not binding until and unless it is turned into an enforceable contract. Then the third procedure that we're going to talk about is conciliation. Conciliation is a dispute resolution mechanism in which a third person or a conciliator assists the party reach an amicable solution to their issues. So in this as well, there will be a third neutral party who will assist in reaching an amicable solution. The difference between conciliation and mediation would be that in conciliation, this third party would be an expert and he will be very actively involved in making sure that you reach a settlement. Whereas when we talk about mediation, that person is there only to mediate. He will only intervene, he or she will only intervene when the communication between the two parties stop. Whereas when we talk about conciliator, he will very actively take part in the discussion and make sure that you guys reach or the parties who are in dispute reach a solution which is amicable and cooperative. And the fourth and the last mechanism that we're going to discuss is negotiation. So, negotiation has been defined as any form of direct or indirect communication whereby parties who have opposing interests discuss the form of any joint action which they might take to manage and ultimately resolve the dispute between them. So, in negotiation, it is not important that a third party or a neutral party would be involved. Negotiation can happen between the parties themselves without involving any third person. What happens is, in negotiation, you're only having a communication which can be direct or indirect, and in that communication, you're trying to resolve your dispute. So these are the four mechanisms that we have to discuss and understand when it comes to ADR, and these mechanisms help in resolving disputes. Thank you so much for listening, and you can follow Legal Edge on its social media handles or contact us on our one stop contact for more information. And let me know your thoughts on the ADR mechanisms and if they help in relieving the court of their burden or not. Thank you.